All right, the Court of Appeals, First Appellate District of Ohio, is the Honorable Beth Meyer presiding. Now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have two cases on our docket to be argued this morning. The first case is Price versus Brooks.
We could file for Mr. Price.
And Mr. Richards, I see you're here on behalf of Applee. If you both will approach to counsel's table. And Mr. File, you will have 15 minutes to argue. Would you like to reserve any of that time?
I don't think I'm going to use 15 minutes, Your Honor.
All right. Whenever you're ready, you may proceed and give Mr. Richards a minute to get settled. Thank you.
Begin, Your Honors.
You may, whenever you're ready.
All right, Richard File on behalf of the appellant, Your Honor. I'm going to be fairly brief, I think, and the reason why is this court last week released an opinion on Staley v. Brooks, which has a lot of issues that are relevant as to the self-help issues that we've already argued, and I think that the court can probably ascertain from that opinion and the briefs that have been filed in this case, the argument that has been made on behalf of the appellant in that case. The issue that I have primarily for trial judge is a violation which we perceive as Evidence Rule 801C. When the trial was commenced, there was issues as to three people providing testimony over objections to hearsay as it relates to the individual, Mr. Price, who was incarcerated. And he was not present in court because he was incarcerated in the State of Ohio Department of Corrections. However, a power of attorney for Shanae Price was admitted without objection, and she testified in full at the trial. She indicated that there was never any permission whatsoever, even though that the landlord testified that there was a phone call, which we objected to. The court indicated that that was a party admission. But there was objections filed at the trial level, and those were preserved. However, Orlando Crawford, who was listed as a resident there, as well as Miss Mosley, and the third party that was listed on that case was a Newsom. They essentially were attempting to provide testimony to the trial court that permission was granted to come to the residence and release the property. We fully objected to that.
Well, Mr. File, on what, I read the transcript. I didn't see where in the transcript there was a specific objection to him saying that, or to the witnesses saying that he gave permission.
I believe that those objections that the court is addressing start on page 35, which relates to the hearsay objections, and continue on page 37, 38, and 39, where all the objections there were noted.
I saw that there were objections to hearsay evidence, but I didn't see where there was a specific objection to Mr. Crawford saying that he gave permission.
Mr. Crawford wasn't present. That's the objection under 801C, Your Honor. He did not testify at trial. The only person that testified at trial.
I understand that. What I'm saying is that when it was Ms. Falk, when Ms. Falk said that he gave permission, and let me actually pull out my notes because I have more specific notes on this.
And again, while you're looking, Judge, Ms. Falk did not testify at trial either.
Okay. Then that would have been Ms. Brooks.
That's correct.
So So on page 39, it said that she went over there to change the locks because she had permission. I didn't see an objection there. I didn't see it on page 40 when she said that she had permission. On page 41, Orlando gave me permission to go into the house and change the locks, remove everything that was left. I didn't see an objection there. So where exactly were the objections?
As I had indicated, Judge, page 35 through 39, we objected to hearsay. I mean, how many times do we have to object to the same thing? We did object. The court overruled me every time and indicated that essentially that they were going to continue to testify as it relates to the phone call. The phone call was not introduced into evidence in this case. We objected to anything related to somebody who was not present in court. The only two people who testified at court were Shanae Price and the appellee, Christina Brooks.
Thank you.
But I think that this all then comes back down to the issue is indicated in the court, in the case that the court just released last week. Is there, in fact, a violation of the self-help statute? And if there is, the question is whether or not there's any damages. I know that there's an issue as to damages in this case, but there's testimony that the damages were $3,000 based initially on the magistrate's decision, but that was not attached because that's not the final appealable order, but it should be a record in the case that's pertaining to this matter.
Mr. Farr, let me ask you a question about that. I know that a layperson's permitted to give an opinion, the value of their personal property. And I know in this case, Ms. Shanae gave an opinion as to her brother's, the value of her brother's property. And I've just not seen that before, but you believe that's permissible?
Yeah.
For instance, I could give a value as to your car if somebody asked me.
If you have firsthand knowledge, and if you look at the cases that were cited, one is Bishop v. East Ohio Gas Company. It says an owner of property is qualified to give opinion as to the value. And I believe Ms. Price testified that she's the one that purchased the bed. Okay. And I think the bed is probably the minimum threshold as to the value of the property because she did testify between $3,000 and $10,000. I have to leave that within the discretion of the court as to determine damages. We understand that there was no documentation as to invoices or bills because the property was all set out and that was set forth at trial. That was a fact that was presented at trial. And also, if you look at, I believe it's Thompson v. Allen also substantiates the same thing, and that was cited in the opinion. We cannot put a sentimental value on anything. It has to be some type of a value, and if the court says it's only worth a penny because we don't have any documentation, that's a value that's been testified to, and I believe that the appellee in its brief acknowledged that there was $3,000 that was testified to at trial, and there was no objection as to that. They're objecting that there was no proof as to the value.
And if you're right, and if we would agree with you, wouldn't the remedy be to return it to the trial court to determine the damages since the trial court found in favor of the defendant?
I would not necessarily object to that because if you look at the opinion that came out last week, that specifically we got shut down on that, and that was on the Staley v. Phillips case. That was my case as well. However, in that case, I think now that the issue becomes the court reversed essentially that there was self-help because the trial court found there was not self-help. Had that trial judge found that there was self-help, maybe there would have been a property or a damage value. We don't know at this point. I think that would be the appropriate remedies. If the court finds that there's self-help and they think that there is some type of damage, then the court can send it back to the trial court for that determination. But we have to get over, first part is that the court dismissed the case in full, indicating that that's the same. And I think if the court finds here again, as they did in Staley v. Phillips, that there was a self-help violation, then I think that that's appropriate, Your Honor.
Thank you.
I really don't have anything further than that, other than what's been set forth in the brief.
I have one more question for
Yes.
you. Assuming if we were to find that the court properly allowed the hearsay evidence in of Mr. Crawford saying that, or of Ms. Brooks testifying that Mr. Crawford gave permission, is it still self-help to take Mr. Price's belongings?
That's our position, is they didn't have any authority to do so. By their own acknowledgement and her own acknowledgement at trial and the magistrate's decision, there was never a notice and there was never a complaint for a forcible entry and detainer Our position is the only way you can physically remove something without authority is by a writ of restitution issued by a trial court after there's been a finding that the parties are in violation of a 3-day notice or a 30-day notice under the Landlord-Tenant Act.
So one of the tenants' permission wasn't enough? She needed to have both of the tenants' permission?
I think that's irrelevant because that tenant didn't testify. So how can that information even be considered in the case as hearsay?
Once again, if we find that the hearsay was properly admitted.
Yes. Then I think you have to look at the further proceedings at the trial level because there was an altercation, law enforcement was called, there was no objection to that. That was found as a fact in the case. She was removed from the property, and when she came back, Ms. Price testified it was all gone. So I
Thank you.
think that's the issue that the court has to address, is whether or not first, was there a self-help violation? If there was, what are the damages, if any? And I think that the issues have been set forth in my brief and my reply. Thank you, Your Honor. Any further questions?
Questions?
No.
You'll have 6 minutes remaining if you'd
thank
like
you,
to
Your Honor.
use them. Mr. Richards, whenever you're ready, you have 15 minutes.
I'm sorry, I couldn't hear,
You have 15 minutes to argue.
I couldn't hear what Mr. File was saying, but anyway, my client, Ms. Brooks, owned the premises in question, and she supposedly spoke to Mr. Price, who was in the Hamilton County Jail at the time, and supposedly he told her she could remove what was in the house, and she took everything, most of the personal property that was there, and put it on the front porch of this house, and left it there for about a week, and of course, Mr. Price was still in jail, and she disposed of the property, and that's about what happened.
Any questions for Mr. Richards?
None for me. Thank you.
Thank you.
Thank you.
Thanks, Steve. Good seeing you, Stu.
So do you have one brief? Your Honor, is it done?
You may. You have 6 minutes left. And Mr. File, if you'll address, and I know you may have addressed this before and addressed it in the brief, but address Mr. Richards' argument that your client is the one who actually gave permission.
That, I believe, you would have to go to, I believe, page 14 and page 64 of the trial transcript where there is a disavow of any permission that is stated that was taken at trial.
But the trial court is free to make credibility determinations, correct?
Yes.
And what if the trial court believed the testimony that your client spoke directly with the defendant and gave permission?
Then I think you have to look at a potential for hearsay within hearsay at that point, Your Honor, because that was substantiated and bolstered by our objections under 801C.
Well, the statement of your client wouldn't be hearsay. That would be one step of it. What's the other level?
Is
Hearsay.
from what apparently Ms. Brooks obtained from Orlando Crawford, Ms. Mosley, and Ms. Falk. I think that substantiates Mr. Richards' belief that there was permission, and if that was not there and that was fully removed, then I think the court has something further to consider under the circumstances, and also the locks were changed as well. There were no keys returned. So I think at this point, yes, you're right, trial court does have the ultimate decision as to addressing the credibility of the testifying witnesses, and I cannot get beyond that because that's appropriate. But I think that you have to take that into context, which was testified actually at trial, and there was a dispute. And I think the first thing that the court has to fully look at is why was there a dispute on the property after the locks were changed and she went in to the premises? That's not in dispute. And I believe also, according to the appellant or appellee's brief that they filed on page 2, it says defendant entered the premises on July 11, 2020. On July 12, 2020, defendant removed the premises. They also indicate defendant spoke to plaintiff on July 11, property left on the porch. And then further, it says Mr. Price provided testimony, which I think is a typographical error because it was Ms. Price, provided testimony that the items left on the porch had an estimated value of $3,000 because Mr. Richards' client did not testify as to value. She would not have known.
All right, thank
Further
you.
questions?
Questions?
No.
All right, thank you, Your Honors.
Thank
Appreciate
you.
your time.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you, Your Honor.
Thank you. The next case on our docket this morning is Andrew versus Dennis. Mr. Whitfield is here on behalf of appellant. The appellee did not file a brief, is not here, and so will not argue. Mr. Whitfield, in light of that, you may have 15 minutes to argue if you'd like, or you may choose to submit it on the briefs. Totally up to you.
Thank you. Good morning.
Good morning.
I don't imagine I'll need 15 full minutes, but I would like to.
All right, certainly. Come on up, and I will keep your time for you. You do have 15 minutes if you'd like to use it.
Yes, thank you. May it please the court, my name is James Whitfield. I represent Mr. Andrew in this matter. And I guess I should address first, I received the notice last week from the court just asking if this case was moot. Because at this point, Mr. Andrew is seeing his child, or he has an order to see his child. I believe he has been exercising parenting time, so he has a happy ending. But I don't think the case is moot, because I think this is a chance for this court to help out a lot of other individuals who go through this process in court. And kind of as I outlined in my brief, I see countless examples of individuals, primarily fathers, established paternity, support order set up, and for various reasons, they still don't get to see their children for months, sometimes even years. And it's denied a lot of times just because of the whim of their parenting partners, the women that they have children with. Like we said, Mr. Andrew was fortunate. He came into my office some time ago. I always advise individuals to file for paternity and visitation / custody at the same time, just based on the process. And it's a very slow process. I'm sure the court is not totally familiar, somewhat familiar with that process. A gentleman can come in, attorney may be established within 3 to 4 months, if that's kind of streamlined, but they may file for visitation custody, and that timeline can be a year to 2 years before anything of structure or substance is actually put on the record.
Yes, Mr. Whitfield, while I am certainly understand what you're saying, and I am sympathetic to this situation, is this the case that we should be addressing this? I mean, because we can't address something that is moot, and as your client has gotten exactly what he wanted, I'm not seeing how this particular case is not moot.
And that's why I need court guidance, because I know, generally speaking, this court can affirm a decision, can reverse a decision, or can remand a decision. That's my understanding.
Or we can dismiss it as being
moot,
moot.
or for any other reason you want to dismiss. So I get those. But I don't know, and it could just be me being naive or just ignorant. I don't know how to stop this cycle. I don't know how to change this process.
Well, it sounds like you want us to direct the juvenile court as to their procedures.
Well, I'll ask you to direct the juvenile court to follow the statute, to follow the law. The law is pretty clear, 3119.08, and I apologize, I think I misstated that in my table of contents in my brief, so I don't hope I cause any confusion, but the statute clearly says that it shall include, when a child support order is originally set up, it shall include provisions for parenting time, visitation, things of that nature. And it doesn't outline how much parenting time should be. It doesn't say you need a full order. It doesn't say a lot of things that it could say, but it clearly states that parenting time should be addressed in some manner, hopefully set up in some manner. Because again, you have individuals paying support for children that they are obligated to support, but they also have a right to see those children. Those children have a right to see them. And the way the process plays out, again, 12 to 24 months later, they still haven't seen these children. And I understand that the court is burdened. I practice in juvenile court here in this county and Butler County as well, and a lot of them do it separately. They keep it separately. The smaller counties, sometimes I go north, the smaller counties, they do everything per the statute. They'll handle it all at the same time. But I think due to time constraints and a lot of the issues that arise in a custody or visitation case, I understand why the court does it that way, but there has to be some kind of structure or some kind of process where an individual can start seeing his children. And it doesn't necessarily have to be immediately, it doesn't have to be overnight visits. You can get into the specifics, whether it's supervised, whether it's an hour per week or whatever it could be. But there should be some kind of minimum standard when a support order goes into an effect, an original support order, because I know there's other variations of orders that come out, but an original support order goes into effect, and I keep saying father, but the gentleman should be able to receive some kind of parenting time order. And again, I don't know who else to ask or how else to get to the issue. I'm sorry, go ahead.
And so your argument is this is capable of repetition, so we should entertain it even if it's moot as to this particular dispute.
Yes, ma'am. It's repeated, it'll be repeated 20 times today. 20 times this week, let me not over it.
And do those other cases usually end up like yours, that it's resolved and that's why we're not seeing them? Or why shouldn't we wait until we have an actual controversy to decide that issue?
Again, because this happens so frequently that there needs to be some kind of relief granted immediately. I'm fortunate I work with a fatherhood project through Tower House, and a lot of those gentlemen come through our program, whether they're dealing with child support issues or whatever. For some reason, they're estranged from their children. They haven't seen their children for some time. Sometimes it's through their own fault, their own actions. Other times it's just because, the breakup was bad. And other times, mothers have genuine concerns about their child's safety. So you have all these reasons, but everyone's not, again, fortunate as Mr. Andrew. They may come in, establish paternity, and then they may file for visitation. And if you file today, was this the end of June, you may get in court in late August, September, maybe now October. The first thing that a magistrate will say to both parties, you have a right to counsel. If she says she wants counsel, then that's another 3 or 4 months. So we're into January, February. And then as you come in court in January, February, she has counsel and she's not in agreement with father receiving parenting time, visitation. You have another 3 or 4 months. You might go through mediation. You might go through settlement conferences. But we're approaching a year at this point. And this child and this man still have not had any interaction. And if he's filed for custody, now he's prejudiced because even visitation to that extent, because now he may not be familiar with the child that perhaps he lived with for 2 or 3 years in a juvenile court setting. But because of the breakup or because of mom's opinion about him seeing the child or because she has that control, his case is kind of lost. He's not familiar with the child. He can't demonstrate an ability to take care of the child. He has no connection or bond to the child. So at that point, the court, understandably, may set up some kind of graduated schedule where they'll do exactly what I'm talking about now. Now let's set up some supervised visits or some very short-term visits, frequent 2-hour visits here and there on the weekends or something that could have been set up back when the fraternity was established. And I think that could be a remedy. That could resolve a lot of things and solve a lot of issues and problems that I see in a lot of these fathers encounter.
Let me ask you this, if you combine both procedures, if the court, juvenile court would agree to do that, wouldn't that push everything back? I mean, aren't there, you just went through a litany of things that will push the case back. If they combined it, wouldn't it just have the same result? It would just be pushed back a year or two, or whatever, until the juvenile court gets to it?
It could be pushed back. I think that would be an issue. But if you set up an interim order or some type, you have a presumption that a parenting time schedule will be granted at the time that support is ordered, a lot of people would be satisfied because they would start seeing their children. And if you read this transcript, that's what Mr. Andrew addressed repeatedly in this case. It was a quick hearing. They set up the support order. I don't think he had any questions about support except for when it would start. But what he repeatedly said was, well, I want to see my child. When can I see my child? She wants me to have supervised visits. I don't think I need that. In the court, I think it was Magistrate McManus, he does as he usually does. You're going to handle that. That's going to be taken care of in your visitation case. And like I said, I'm not going to say most, but a lot of individuals don't know that they should file both at the same time.
Is that the reason why we're not seeing more of these cases? Because what I'm understanding from you, and correct me if I'm wrong, is that you're saying that the juvenile court is not following the statute because it is not making an order on parenting time at the same time as the support order, correct?
Yes, ma'am.
So my question is, if that is the norm in this county, why aren't we seeing more of these cases that are actual, at the time, live controversies when it reaches us?
I think it's a couple of reasons. I think number one, a lot of pro se litigants aren't aware of the statute.
Okay.
So they don't know that they should be getting some kind of parenting time order when child support is issued. They have a feeling, they say it based on common sense. I'm paying all this money for child support, how come I can't see my child? I hear that all the time. So they kind of intuitively know, but they don't know that there's a statute. Number two, maybe not a lot of attorneys pay attention to the statute, but for those that do, you have to have kind of, not a unique set of circumstances, but it has to be an original order, as Mr. Andrews was, not a modification of support, things of that nature. Obviously, if it goes to DR court through domestic relations, they touch on all these issues. But again, if it's not an original order, then this statute doesn't apply. They really don't have to issue visitation at that time or any other parenting time orders. So I think that combination creates a situation where a lot of people, either they don't know that they can try to enforce their right to see their child, or it's not under the statute. There's ways to kind of wiggle out. What the court does a lot of times, because I've been bringing it up for maybe 4 or 5 years, they'll do what magistrate men often do. We'll waive the filing fee for you. You have to file that separate. We'll waive the filing fee. We'll allow you to do that.
I thought you said you filed both at the same time.
Mr. Andrew filed both at the same time, just because I advised him to do so.
Right.
I didn't represent him at the time. I obviously didn't represent him underneath the child support case, but I advise individuals who come into my office or when I work with fatherhood, file everything at the same time because it's such a slow process. So again, it worked out for Mr. Andrew, but a lot of individuals don't know that. They don't understand that process. They don't understand how slow it is. Even when they do file for visitation of custody and they get to that first hearing, they're very disappointed to find out we're not going to hear anything on the merits today. We're not going to hear about any facts. Because what the court typically does, if the moms don't agree, all the magistrates aren't like this, but the majority have been and still are. If the moms don't agree to some kind of visitation, then they're not going to order it. And understandably so, because they haven't heard any of the facts. So to kind of go all the way back to your question, if there's some kind of presumption that this man, who's been ordered to pay support, that he's presumed to have at a basic minimum, the ability to keep his child safe for, just say 2-3 hours, and that minimum order goes into effect, then that satisfies the statute, and that can somewhat alleviate a lot of the complaints I hear about, a lot of worries where I don't get to see my child. I'm paying $500 a month. I've been paying $500 a month for 2 years. I don't get to see my child. And it also avoids that you always hear, you know, a man and a woman, a father and a mother start off on equal footing in court. And practically, that's not the case. It's not true. And I know that's way outside of what the court can discuss or when they hear about today. But it plays out over and over under the situation, as I said before. Because fast forward to 18 months later at a custody trial, I haven't seen my little girl in over a year and a half, maybe 2 years. She doesn't know me anymore. I can't get custody as long as mom's doing what she's supposed to do. And I assume that parents want to take care of their kids and raise them and be responsible and provide, you know, all the things that they need to and nurture. Unfortunately, that doesn't always happen, but that's the presumption. So that presumption should go to a father as well, who's instantly placed on and in a situation where he's obligated to make payments. And if he doesn't make those payments, he's subject to contempt. He can lose his license. He's open to all those sanctions. But at the same time, he doesn't get to enjoy the rights that are supposed to be afforded to him because he established and tried to fight for paternity. And that's exactly what Mr. Andrew did. So he was a lucky one. He kind of snuck through. So I do understand that, and I do get that. But again, I don't know any other way to bring this issue to light, to help all these individuals who are trying to see their children, to help all these children who are being, for some reason or another, withheld from a parent. And they haven't done anything to deserve that. Again, I don't know what, if any, the court can do, if they can make a specific or general execution to the court or a recommendation to the court. I just don't understand fully, and again, it's just my ignorance, what the court can do. But I hope the court can do something. I'm asking the court to do something to help these individuals, to help these families, to stop this cycle from repeating itself. A lot of the individuals are like Mr. Andrew. They just want to see the child. He's a young man. I think he's in his early 20s. I'm just asking for some assistance. Mr. Andrew, again, he's a happy ending seeing his child. But the statute's clear. The statute's enforceable. There's a case in Butler County from several years ago where they remanded the case because the support order was issued, but the father was not granted some parenting time orders. That was in Ray CEJ. It was like in 2014. But as kind of alluded to, this isn't something that comes up often. A search for the statute revealed maybe 10 cases throughout the state. So I'm not sure why it's not used, why it's not utilized, but it's there. And it's a very useful statute that needs to be enforced. And I'm asking something to change in Hamilton County today.
Thank you, and that was perfect timing because you are at your time, believe it or not, with our questions and your arguments. We did take the entire 15 minutes, but thank you very much for your argument this morning. We will give you a timely written opinion on this case.
Thanks for listening.
Thank you.
Have a good day.
That will conclude our arguments this morning for the First District Court of Appeals.